Hello friends, I Sandeep Yadav welcome you all in this video. In this video, we are going to discuss some important MCQs on Companies Act 2013. So let's start the video. The first question is, property of the company belongs to company, shareholder, members or promoter? And the correct answer is a company. Property of the company belongs to company. कंपनी की प्रॉपर्टी ये कंपनी की ही प्रॉपर्टी होती है. बहुत सारे लोगों को लगता है कि कंपनी की प्रॉपर्टी शेयर होल्डर की प्रॉपर्टी होती है, बट द कंपनी की प्रॉपर्टी सिर्फ एंड सिर्फ कंपनी की ही प्रॉपर्टी होती है, बिकॉज देयर इज वन इम्पॉर्टेंट फीचर ऑफ अ कंपनी इज सेपरेट लीगल एंटिटी. Because of this separate legal entity, company can hold property on its own name. Therefore, here the correct answer is A, company. Next question is, the term company is defined under which section of the Companies Act 2013? And the options are section 2 subclause 5, section 2 subclause 20, section 2 subclause 34, section 2 subclause 62, and the correct answer is section 2 subclause 20, because section 2 subclause 5 deals with the article of association, section 2 subclause 34 deals with the term directors, section 2 subclause 62 defines the term one person company, and section 2 subclause 20 defines the term company. Here, therefore, here the option B is the correct answer. Now, next question is, which company shares can be freely transferable? Private company, public company, both A and B, and last option is none of the above. Which company shares can be freely transferable? And the correct answer is public company. Yes, public company shares can be freely transferable. Here both company shares, whether that company is a private company or public company, both company shares are transferable. But in case of private company, there are certain restrictions on the transfer of shares. The shares of a private company can be transferred among their members only. This restriction is applicable to the private company. Therefore, we can say private company shares are not freely transferable. But in case of public company, the shares of a public companies are freely transferable. Nowadays, through the demat accounts, the shares of a public company can easily transferable, can freely transferable. Therefore, here option B is the correct answer. Option B is public company. Now, let's move toward the next question. Maximum number of members in case of private company is, options are 50, 100, 150 and 200. Here the correct answer is 200. In Companies Act 2013, the maximum number of members in private company is 200. In 1956, that figure was 50, but today the present Companies Act 2013 is applicable, and according to Companies Act 2013, in private company there may be a maximum number of members, that is 200. So let's move towards the another few questions. You can see here the chart is before you. In this chart, we are going to discuss minimum and maximum number of members as well as directors in different companies. Now, in one person company, इन वन पर्सन कंपनी में मिनिमम मेंबर्स कितने होने चाहिए, दैट इज 1 एंड मैक्सिमम आल्सो 1, बिकॉज इन वन पर्सन कंपनी, कंपनी का नाम ही क्या है, वन पर्सन कंपनी. विच कंपनी इज कॉल्ड वन पर्सन कंपनी? One person company means a company which has only one person as a member. Therefore, in one person company, minimum एक member होता है and maximum भी one ही member होता है. In case of private company, minimum 2 members are required, and in private company there may be a maximum number of members, that is 200. In public company, minimum 7 members is required, and in public company there is no limit on the maximum number of members. This is all about the members in one person private and public company. Now let's see about the directors. In one person company, minimum 1 director is required, and there may be the maximum 15 director in one person company. In the same case, in a private company, minimum 2 directors are required and maximum 15 directors. In public company, minimum 3 directors are required in maximum 15. Means in your examination point of view, आपको ये याद करने के लिए बहुत ईजी रहेगा कि मैक्सिमम नंबर ऑफ डायरेक्टर्स इन एनी काइंड ऑफ कंपनी, वेदर दैट कंपनी इज अ वन पर्सन कंपनी, प्राइवेट कंपनी और पब्लिक कंपनी, मैक्सिमम मेंबर्स कितने होते, सॉरी मैक्सिमम डायरेक्टर्स कितने होते, वो होते 15 डायरेक्टर्स. एंड यहाँ पे देख लो कि वन पर्सन कंपनी में 1 डायरेक्टर, प्राइवेट कंपनी में मिनिमम 2 डायरेक्टर्स एंड पब्लिक कंपनी में मिनिमम 3 directors are required. Means 1, 2, 3 directors are required in one person company, private company and public company. So examination point of view, this chart is very important. So let's move towards the next question. Our next question is the liability of members in a company limited by guarantee. The liability of members in a company is limited by guarantee is unpaid amount of the shares, unlimited liability, guaranteed amount and none of the above. Here the correct answer is C, guaranteed amount. Where the company is limited by guarantee, the liability of the members in a company limited by guarantee is guaranteed amount. अब सबको मे भी पता रहेगा कि मेमोरेंडम ऑफ एसोसिएशन का जो गारंटी क्लॉज होता है, उस गारंटी क्लॉज में जो अमाउंट लिखी होती है उतनी अमाउंट के लिए कंपनी लिमिटेड बाय गारंटी के मेंबर्स लायबल होते. Okay, therefore here the correct answer is answer C, guaranteed amount. Now next question, the liability of members in a company limited by shares is unpaid amount of the shares, unlimited liability, guaranteed amount and none of the above. Here the answer is A, unpaid amount of the shares. Means where a company is limited by shares, the liability of its members is limited up to the extent of unpaid amount. Means जो अमाउंट शेयर होल्डर ने पे नहीं की होती है उतने अमाउंट के लिए वो लायबल होते. ओके, सो नेक्स्ट क्वेश्चन इज the Companies Act 2013 is applicable to option A, companies incorporated under this act or any previous company law, B, insurance and banking companies, C, companies engaged in the generation or supply of electricity, and D, all of the above. Here the correct answer is all of the above. This Companies Act 2013 is applicable to all those companies which are incorporated under this act. This act means 2013 Act, as well as under any previous company law. Here, which are those previous company laws? 1956 Act, 1913 Act, Companies Act 1866. Means all those companies which are incorporated under the present Companies Act 2013 as well as under previous company laws, to those all companies, Companies Act 2013 is applicable, as well as the present Companies Act 2013 is also applicable to all insurance and banking companies, as well as all those companies which are engaged in the generation or supply of electricity. Therefore, here option D is the correct answer, all of the above. Next question. The principle of separate legal entity of a company was recognized in the case. In which case this principle of separate legal entity is recognized? Options are Balfour versus Balfour, B. Salomon versus Salomon and Company Limited, C. Ashbury Railway Carriage and Iron Company versus Riche, and D. Royal British Bank versus Turkulent. मीन्स ये जो सेपरेट लीगल एंटिटी, ये जो प्रिंसिपल है, फर्स्ट टाइम किस केस में रिकॉग्नाइज किया है? यहाँ पे करेक्ट आंसर है यस, आंसर बी, Salomon versus Salomon and Company Limited. For the sake of your knowledge, I must say you the Balfour versus Balfour, this case law deals under the Indian Contract Act. Indian Contract Act में एक कॉन्सेप्ट है इंटेंशन टू क्रिएट लीगल रिलेशनशिप, उससे रिलेटेड ये बाल्फोर वर्सेस बाल्फोर केस लॉ है. Ashbury Railway Carriage and Iron Company versus Riche, this case law deals with the doctrine of ultra virus. And the last जो ऑप्शंस में केस लॉ बता दिए वो है रॉयल ब्रिटिश बैंक वर्सेस टर्कुलेंट. दिस केस लॉ डील्स विद द डॉक्ट्रिन ऑफ इंडोर मैनेजमेंट. मीन्स हियर this regarding to separate legal entity, this separate legal entity is recognized in which case? That case is Salomon versus Salomon and Company Limited. Now next question. After registration of a company, the Registrar of Companies issue a certificate known as Certificate of Commencement of Business, Certificate of Incorporation, Prospectus, and none of the above. Here the correct answer is Certificate of Incorporation. Means what? Once the company is registered, the registrar, ROC, Registrar of Companies, will issue one certificate. That certificate is known as Certificate of Incorporation. Certificate of Incorporation. Now next question is CIN stand for College Identity Number, Corporate Identification Number, Corporative Identity Number, and Case Identification Number. Here the CIN stand for option B, Corporate Identification Number. जब कोई कंपनी रजिस्टर्ड होती है तब ROC उस कंपनी को एक नंबर देता है, उस नंबर को हम कहते हैं CIN नंबर. एंड यहाँ पे CIN स्टैंड फॉर कॉर्पोरेट आइडेंटिफिकेशन नंबर, ये उस कंपनी का नंबर होता है. नाउ लास्ट क्वेश्चन हम देखने जा रहे इस वीडियो का, क्वेश्चन नंबर 11. ABC private limited company is a private company having 5 members only. All the members of the company were going by car to Mumbai in relation to some business. An accident took place and all of them died in a car accident. Whether the company will exist? Option is yes or no. वेरी इंटरेस्टिंग केस स्टडी है ये. इस केस में क्या हो चुका है, एक कंपनी ABC प्राइवेट लिमिटेड एक कंपनी है, उस कंपनी में 5 मेंबर्स थे. ये 5 पूरे मेंबर्स एक कार में बिजनेस पर्पस के लिए मुंबई जा रहे थे. जब वो मुंबई जा रहे थे उसी दौरान क्या होता है कि उनका एक एक्सीडेंट होता है और उस एक्सीडेंट में जो 5 मेंबर्स थे उस कंपनी के, all 5 members died in a same car accident. Now the question arises whether the company also died in the same accident or whether the company will exist. Yes or no? The correct answer is yes. Company will exist because here the company is having separate legal entity apart from these members. Company is having separate legal entity apart from their members. Therefore members can comes and goes but company goes forever. यहाँ पे पूरे 5 members की अगर डेथ भी होती है तो भी कंपनी सर्वाइव करेगी. Therefore the option number A is the correct answer. Yes, the company will exist. I hope आपको ये वीडियो पसंद आया होगा. अगर आपको ये वीडियो पसंद आया है तो इस वीडियो को लाइक कीजिए, शेयर कीजिए, सब्सक्राइब कीजिए और बेल आइकन दबाना मत भूलिए. थैंक यू.